Title 5 Civil Liability Chapter 1 Persons civilly liable for felonies Article 100 Civil liability of a person guilty of felony. Every person criminally liable for a felony is also civilly liable. 101 Rules regarding civil liability in certain cases. The exemption from criminal liability established in subdivisions 1, 2, 3, 5, and 6 of Article 12 and in subdivision 4 of Article 11 of this code does not include exemption from civil liability, which shall be enforced subject to the following rules. First, in cases of subdivisions 1, 2, and 3 of Article 12, the civil liability for acts committed by an imbecile or insane person and by a person under 9 years of age or over 9 but under 15 years of age who has acted without discernment shall devolve upon those having such a person under their legal authority or control unless it appears that there was no fault or negligence on their part. Should there be no person having such insane, imbecile, or minor under his authority, legal guardianship or control, or if such person be insolvent, said insane, imbecile, or minor shall respond with their own property, excepting property exempt from execution in accordance with the civil law. Second, in cases falling within subdivision 4 of Article 11, the persons for whose benefit the harm has been prevented shall be civilly liable in proportion to the benefit which they may have received. The courts shall determine, in their sound discretion, the proportionate amount for which each one shall be liable. When the respective shares cannot be equitably determined, even approximately, or when the liability also attaches to the government or to the majority of the inhabitants of the town, and, in all events, whenever the damage has been caused with the consent of the authorities or their agents, indemnification shall be made in the manner prescribed by special laws or regulations. Third, in cases falling within subdivisions 5 and 6 of Article 12, the persons using violence or causing the fear shall be primarily liable and secondarily, or if there be no such persons, those doing the act shall be liable, saving always to the latter that part of their property exempt from execution. 102. Subsidiary civil liability of innkeepers, tavern keepers, and proprietors of establishments. In default of the persons criminally liable, innkeepers, tavern keepers, and any other persons or corporations shall be civilly liable for crimes committed in their establishments in all cases where a violation of municipal ordinances or some general or special police regulations shall have been committed by them or their employees. Innkeepers are also subsidiarily liable for the restitution of goods taken by robbery or theft within their houses from guests lodging therein, or for the payment of the value thereof, provided that such guests shall have notified in advance the innkeeper himself or the person representing him of the deposit of such goods within the inn, and shall furthermore have followed the directions which such innkeeper or his representative may have given them with respect to the care of and vigilance over such goods. No liability shall attach in case of robbery with violence against or intimidation of persons unless committed by the innkeeper's employees. 103. Subsidiary civil liability of other persons. The subsidiary liability established in the next preceding article shall also apply to employers, teachers, persons, and corporations engaged in any kind of industry for felonies committed by their servants, pupils, workmen, apprentices, or employees in the discharge of their duties. Chapter 2. What civil liability includes? 104. What is included in civil liability? The civil liability established in Articles 100, 101, 102, and 103 of this code includes 1. Restitution, 2. Reparation of the damage caused, 3. Indemnification for consequential damages. 105. Restitution. How made? The restitution of the thing itself must be made whenever possible, with allowance for any deterioration or diminution of value as determined by the court. The thing itself shall be restored, even though it be found in the possession of a third person who acquired it by lawful means, saving to the latter his action against the proper person who may be liable to him. This provision is not applicable in a case in which the thing has been acquired by the third person in the manner and under the requirements which, by law, bar an action for its recovery. 106. Determine the amount of damage, taking into consideration possible and its special sentimental value to the injured party, and reparation shall be made accordingly. 107. Indemnification. What is included? Indemnification of consequential damages shall include not only those caused the injured party, but also those suffered by his family or by a third person by reason of the crime. 108. Obligation to make restoration, reparation for damages, or indemnification for consequential damages and action to demand the same, upon whom it devolves. The obligation to make restoration or reparation for damages and indemnification for consequential damages devolves upon the heirs of the person liable. The action to demand restoration, reparation, and indemnification likewise descends to the heirs of the person injured. 109. Share of each person civilly liable. If there are two or more persons civilly liable for a felony, the courts shall determine the amount for which each must respond. 110. Several and subsidiary liability of principal preference in payment. Notwithstanding the provisions of the next preceding article, the principals, accomplices, and accessories, each within their respective class, shall be liable severally in solidum among themselves for their quotas, and subsidiarily for those of the other persons liable. The subsidiary liability shall be enforced first against the property of the principals, next against that of the accomplices, and lastly against that of the accessories. Whenever the liability in solidum or the subsidiary liability has been enforced, the person by whom payment has been made shall have a right of action against the others for the amount of the respective shares. 111. Obligation to make restitution in a certain case. Any person who has participated gratuitously in the proceeds of a felony shall be bound to make restitution in an amount equivalent to the extent of such participation. Chapter 3. Extinction and Survival of Civil Liability. 112. Extinction of civil liability. Civil liability established in Articles 100, 101, 102, and 103 of this Code shall be extinguished in the same manner as other obligations in accordance with the provisions of the civil law. 113. Obligation to satisfy civil liability, except in cases of extinction of his civil liability as provided in the next preceding article, the offender shall continue to be obliged to satisfy the civil liability resulting from the crime committed by him, notwithstanding the fact that he has served his sentence consisting of deprivation of liberty or other rights, or has not been required to serve the same by reason of amnesty, pardon, commutation of sentence, or any other reason.